Hi, my name is Pittman. So last summer, I was kind of shocked by a news story I saw in Chile. It was in August of 2012. The Supreme Court of Chile unanimously rejected environmental licenses for this thermoelectric coal-fueled power plant in central Castilla and an accompanying shipping port, Puerto Castilla. And I was mainly shocked by this just because Chile, typically has its reputation for being a very business-friendly country, particularly by Latin American standards. Their general policy is to have a very robust economy, and they're usually seen as kind of the place to look to for economic growth. And so this was really surprising me that they would kind of go against this this new, very large investment from German and Brazilian companies. And so I decided to look into it a little bit more. So my paper today, the presentation I'm giving, is going to take a look at a couple of these case studies, like this Castilla power plant, and also give a brief overview of the current energy needs in Chile and their environmental legal system that kind of caused this power plant to get struck down in the Supreme Court. And so since the court's ruling, the court ruled that they would have to submit a new energy impact assessment, which I'll explain in a little bit. But having already invested $40 million in Chile, the main companies behind it said they would have to rethink their investment strategies in Chile, and they've since not really announced anything about their reassessment. So this is kind of a serious problem because Chile is in a little bit of an energy crisis right now. About 75% of the energy supply comes from imported fossil fuels. Even though they have a large mining industry, it's mostly minerals. It's not actually as much in the way of fossil fuels. And they're currently undertaking efforts to pursue renewable energy. They briefly thought about nuclear energy, but after kind of the disaster in Japan recently, that's off the table. And in addition to having a need for more energy supply, there's also problems with their energy infrastructure system, with the delivering energy to places. They have two main electricity grids, but both of them suffer from weak links. It's a very mountainous country, a lot of seismic activity, and so these weak links can cause some pretty serious problems. And the Castilla plant in particular that got struck down was going to supply power to a northern portion of one of the main grids, which is weakly connected to the rest of the system. So in many ways, it would have been a pretty positive development. Here's a grid of the electricity generation, and you can see a large amount of it comes from oil, coal, and hydroelectricity. And there's also been a lot of concerns over hydroelectric generation. So move on to the environmental law before we take a look at the case studies. After the transition out of the Pinochet regime, the Concertación government that kind of took over, their main goals were to kind of incorporate a lot of the really liberal and progressive social justice movements in Chile at the time into the government. So they wanted to have a more liberal government than Pinochet, but at the same time they did not want to sacrifice the economic growth that Pinochet had fostered. And so, normally their approach was to take any kind of social justice movements and incorporate them into the government, but they never really did that so much with the environmental movement, mainly because it was seen as just directly at odds with economic growth. So there are a few things in the Constitution that gives a nod to the environmental movement, but it was never really fully incorporated. So Article 19 has a provision saying that the right to live in a clean environment is secured, and that it's the duty of the state to make sure that this right isn't effective and to have guardianship over the natural environment. There's also a constitutional guarantee of the right to property, which says that it can be limited by law for public health, public utility, and conservation of the environment. And there's one article in particular that gives people a right of action to go to court to secure their constitutional rights, even if they have not yet been violated. And this is a really important provision because it has, unlike a lot of aspects of Chilean law, there's very little formality formalities required. Pretty much anyone can file one of these actions with very little expertise and very little expense. And so that's, even though there are a couple of other ways to try to get compensation, say after the fact there's been environmental damage done, most of the environmental groups use this course of action because it allows you to stop environmental damage from happening. Or stop, rather it allows you to stop any damage to your constitutional rights from happening, but that would include your right to a clean environment. So, as I said, the issues weren't really addressed in the early stages of the government until 1992 when Chile wanted to join NAFTA. The U.S. Congress had given President Clinton this fast-track authorization status where as long as certain provisions were met, he was authorized to enter into a treaty with these countries. And one of those provisions was that the countries had to have a certain minimal level of environmental protection, and Chile didn't really have any. And so the Chilean legislators started looking around, seeing what kind of proposals they could do. They thought about having a Ministry of the Environment, like a lot of other countries did, but instead they adopted something a little bit different. This is called the National Environmental Framework Law. And there's a lot of evidence at the time that really the entire debate around this law was really driven by NAFTA. It was not driven so much by environmental concerns. There were a few legislators who wanted environmental protection. This was mostly supposed to be a business-oriented environmental law. So it established this National Commission on the Environment, CONAMA, which was a body of 10 ministers charged with setting policy and enacting regulation. And then there were regional commissions. And their main function was to decide on these environmental impact assessment petitions. So the idea is, there are various other regional agencies that has some control over the environment, like agencies that would regulate water pollution or something. They weren't really environmental agencies. And so the regional, the COREMAs, their main duty was to kind of coordinate all of these different regulations. And whenever a developer was proposing a project, instead of having to make sure they're abiding by all these different agencies' regulations that might impact the project, they can just go to a COREMA, submit, if they need to, they can submit some kind of assessment, and the COREMA will decide whether they meet all the requirements. And so it's this, they call it a ventana única, like a one-stop shop. And so it's supposed to be, like I said, very developer-friendly. And so they can require two different forms of assessment for developers. There's a study and a declaration. The studies are very detailed, contain substantial analysis of all the different kinds of impact that this development will have. And a declaration just has a short description of the project, and you just kind of affirm that you're in compliance with environmental laws. You don't really have to show anything. So there are a lot of different things that can require studies. So if there's a risk to human health, significant adverse effects on natural resources, if you're going to be relocating human communities, if you're in a close proximity to certain areas like tourist areas or areas that are just considered to have a lot of environmental value or cultural and historical value. So whichever kind of thing you submit, the regional agency only has 5 days to verify whether you meet the requirements. So this is, like I said, supposed to be very friendly to the developer. You can kind of just get on with the project. Copies are sent to each of the departments that might be involved, and each department may submit a report back to the COREMA, the regional agency. The study is made available to the public, except for any confidential information, which is not very well defined. And substantive decisions are expected to be made within 120 days for studies and 60 days for declarations. Sometimes they will, they are able to kind of make an extension in certain cases if it's a good project. But only about 4% of submissions are rejected. If the COREMA fails to respond at all, that's deemed to be an acceptance, just in accordance with normal Chilean administrative law. Another interesting fact about it is they get these reports back from the various other agencies involved, but there's no real rule over when they can accept or reject. So each agency involved, in theory, could send a really scathing report saying this doesn't meet any of our requirements for any of our water safety laws, and the COREMA could still say, yeah, you can go ahead and proceed with them. case of these case studies, it's necessary to understand a little bit about this recurso de protección. So there are a few limitations on it. It has to be filed within 30 days of the act or omission that will affect the right. But it is inexpensive. You file directly to an appeals court, and then you can appeal again to the Supreme Court. Let's go straight to the case. So in this Central Castilla case, they filed two separate environmental impact studies. They had a power plant and a shipping port. The opponents filed recursos against both, but since they were in different regions, they went through two separate courts at first. The Supreme Court rejected both plans, but not so much over any substantive issue with the environmental protection, but because there was a connection system between the power plant and the port, and they didn't submit a study over that. So, in theory, the court said, just submit a new study, do a new study, go back through the system, and in theory, it should be fine. But I think there's some sense that the court was really motivated to find some reason to strike this down because of the environmental impact, but they didn't actually want to rule on the constitutional issue of a right to a clean environment, so they found a procedural ground to strike this down. Similarly, there's a proposed $7 billion hydroelectric project in the Patagonia region of Chile, and it would generate nearly a third of the capacity for one of their major grids within 12 years. It wouldn't displace many people, but it would involve flooding over 14,000 acres of land, eliminating a lot of waterfalls. I mean, this is Patagonia, huge tourist area, and it would cause a lot of changes in it. So, they filed some environmental groups, so protesting it filed a court action against this proposed dam. So after it was approved, the opponents challenged it, and the court, they initially wanted an injunction against it, but the Supreme Court, after examining the evidence, overturned the injunction. The opponents had alleged that there were a lot of conflicts of interest in assessing the environmental impact. A lot of people that have jobs in these ministries have ties to the industries that they're overseeing. And they also said that there were a lot of negative environmental reports that the Corema just ignored. But the Supreme Court ruled that it did not violate the constitutional rights of the opponents and refused to consider any evidence relating to the negative assessments based on procedural grounds. And the companies behind the project, however, still halted the project, stating that there was a lack of a clear energy policy in Chile. There were also a lot of threats from the environmental groups to take this case to the Inter-American Court of Human Rights. And so even in these cases, you can see where the courts do rule in favor of the developers, and it does get upheld. There's a sense that because of this perception that there's too much of a politicization of their environmental law, there's a lot of stronger mobilization on the part of these environmental groups. And so my basic policy proposals would be that in order to fix a lot of these problems, Chile actually needs to enact more substantive environmental laws. There needs to be more centralization of the substantive lawmaking process, not just a centralization of the enforcement process. And also more rules. This would basically become in the form of more rules on how the Coremas approve their studies. Instead of just saying they consider these reports and then give their approval or not, there should be some kind of standard on how the vote on the ministers in the Corema is conducted. Also, another good change would be to allow the Coremas to require modifications in order for approval, so additional approval. This would kind of balance the need to go ahead and start proceeding with the development, but also have oversight throughout the whole process instead of just getting straight approval. And that pretty much concludes my presentation on this.